But I appreciate your time today, and I'd be happy to answer any questions that you may have.
Thank you very much. Does anybody have a question? Representative, please.
I've got just a couple just for clarification. Dealing with the assisted animals, you go into emotional support animals do not need to be certified. What if we're dealing with like a known vicious breed in terms of training and things like that, requesting a certification that the animal has been properly trained and isn't a risk to possibly mauling somebody?
Totally understand what you're saying about that, and that is something that's provided for in the statute, that there's an exception for any accommodation that might be dangerous. There can't be a blanket breed disqualification. It has to be based on the individual animal and that individual animal's proclivity to viciousness or any history of attacking someone or being threatening. So a blanket disqualification of, say, we don't take Staffordshire Terriers wouldn't be acceptable. But if you had, someone was coming in with their totally untrained and unruly animal that they weren't caring for, that would definitely be a reason to say, we can't have an animal that would be dangerous to our other tenants here.
Thank you. And then one other.
And concerning certification.
Mm-hmm. Well, that answered my question. You didn't answer my question, so I appreciate that. Thank you. That clarified. Just wanted to see if that was there. Thank you.
Okay.
And then my other question, coming around to me dealing with harassment. It deals with neighbors harassing children or parents, things like that. And maybe this is outside of your wheelhouse necessarily, but in states where there's just cause evictions, does harassment of other tenants generally fall into that category as a just cause eviction?
I actually don't know,
Okay.
But I suspect that if that were the case, it would be, because that's prohibited by our fair housing laws.
And again, like I said, I just wanted to just make that as a note that if that was something that was going to be considered coming out of this commission, that the conflict between the two, would need to be addressed definitively to make sure that I can't have my tenant harassing somebody, but at the same time I can't evict my tenant for harassing somebody. So I just wanted to make sure that if we were going to go in that direction, that would be addressed. Thank you.
Absolutely.
So if somebody has a policy of they can't have it under this law.
So if they have a policy of,
A 10-unit apartment, I don't think they have it. Okay.
so yes, you can absolutely have the policy, but you would have to accommodate the policy for someone who requires that accommodation of an emotional assistance animal.
All right, so what is an assistance animal?
So an assistance animal is one so the assistance animal is the blanket term for both service animals and emotional support animals. And under the fair housing laws, that's the term that's used. And it's an animal that is necessary for someone to be able to have full use and enjoyment of the property.
Okay, because there's been a lot of cases around the country where people wanted to take a snake on a plane because that was their comfort animal. Or my comfort animal is a rat. And would that have to be accommodated?
Not necessarily. So it's...
Under what circumstances would it have to be accommodated?
So it's not necessarily that I can just say, this is my comfort animal and I can bring my my antelope into the, just to give the most absurd example. Under the HUD guidance, I think it's HUD guidance, it has to be a commonly domesticated and animal kept as a pet.
So a dog or a cat?
Dog, cat, could be a lizard. We've had emotional support chickens. And I know that sounds somewhat suspect, but part of the emotional aspect is it may be that caring for them provides emotional support for the person, not just that it's a cat and they sit in my lap and that provides me comfort. But
It wasn't horse and dog,
Okay.
but chickens, snake, buffalo. There are instances in which they could be covered as a company.
Probably not a goat if you're talking about inside of a property. A snake could be covered, but it's not. So typically, when people make these requests for reasonable accommodations, they're accompanied by some sort of medical documentation. So like a letter from a doctor or a prescription from a therapist saying that this person has this diagnosis, I've been treating them, or they have this disability, I've been treating them, and part of their treatment or what's necessary for them to be able to fully use this dwelling is to have their emotional support animal. So most of the time it's accompanied by some sort of medical documentation. And it's perfectly fair for a landlord to ask questions about, what kind of animal is this? And, can you provide me some documentation? And, but I do understand the concerns. And like I said, we see a lot of these emotional support animal cases. But I would also say that something like taking an animal on a plane or on a bus or in a public area is governed by a completely different law from fair housing. So the idea being that this is an animal that's in your dwelling as opposed to you're taking it out in the public.
So it's become clear that you could go online here in Rhode Island and have one virtual session with a doctor in Florida or Texas or something, and they will sell you basically this letter. What are your thoughts on that? Maybe, should they require maybe more than one visit or certain? I know other states have laws like that where you have to have so many hours of therapy before you can get this letter. It seems very easy to get this letter here in Rhode Island.
And I think it's totally fair if you're the property owner and you see that someone is presenting you this certificate that says, this is my emotional support, person, and it's an out-of-state provider, and they don't have a history of treating that person, to, question that. As far as like what should be put in place to address that, I haven't given it a lot of thought to be able to speak on that, but I think that is something that needs to be considered is, how to guarantee that it's a genuine need while still respecting the rights of the person who has a disability.
Requirements in the law with respect to insurance companies. So let's say you have someone who has a genuine need for. There you go.
A genuine need for this animal, and it's certified, they passed all the tests, but it happens to be what the insurance companies call a malicious breed. Think of the words you used. The insurance company says, if you get this breed, we're going to stop your policy, right? Are there any protections for the homeowner in that situation so that they can comply with allowing this person to come in with this assistance animal and not losing their insurance? Or do they have to make a choice between accepting this person and losing their insurance?
So unfortunately, I'm not an expert on property insurance. I'm aware of the situation you're describing, though, and my understanding is that the insurance provider has to also accommodate for an animal that there's for a service animal, so to speak. I don't think it's down to the property owner to make the decision like, oh, I'm going to drop my coverage or have to accommodate a service animal. But again, like I prefer to go do some research and get an answer for you because I'm not totally familiar with the insurance aspect.
Thank you.
Rep. Morales?
Thank you, Chairman. Lauren, I have a question as it relates specifically to the process for a prospective tenant who unfortunately is a victim of source of income discrimination. Because unfortunately, I still hear constantly from constituents as relates to seeing advertisements online saying no Section 8 accepted, or they show up to see the property and they are told, oh, you're a voucher recipient, we're not going to be renting to you. So can you walk us through the process specifically as it relates to the investigation that is conducted by the Human Rights Commission? And obviously, depending on the investigation, I'm sure that influences the timeline. But if you could also just walk us through what that timeline looks like, and then generally speaking, what are the next steps if there is found to be probable cause?
So with timeline, you're talking about how long it takes from filing a complaint to getting a disposition. Is that correct? Okay. So on average, our case processing time is just a little under a year. So yeah, I mean, that's a significant concern for someone who's reporting something like source of income discrimination. That being said, that's an average and it doesn't represent all of the cases. And a source of income discrimination case is a little more straightforward than some of the other types. So in the investigation, the investigator would be seeking information about if there are any other tenants at that property who are voucher holders, or who have other sources of income, whether if there's a discriminatory advertisement, that's pretty straightforward. But if you're getting into something about the property owner told me that I can't use a voucher, and you're having to do more investigation about credibility of witnesses and so forth, that could take a little more time. But I would say that it's not an immediate process. I will say, though, that a lot of times we're able to negotiate settlements on those kind of cases. I think some people are maybe not aware of the requirements for a Section 8, and once they are aware, they're perfectly happy to accept them. And we've been able to negotiate some settlements around people are being able to use their vouchers. As far as what happens after there's a determination of probable cause, one of two things: either the case will go to a commission hearing, and the commission hearing, if they find in favor of the complainant, they can award damages, as well as a civil penalty, which is just basically a fine that goes to the general treasury. If either one of the parties wants to take it to Superior Court, it would proceed just like a court case, where it would have to be filed and it would go into discovery, and then there would be a trial.
Thank you very much. Did you have another question, Reverend Ross?
Just based on my experience, the Section 8 voucher, the problem is they just don't pay enough to come to current market value. That's why people not educated enough to say, oh, I'm not taking Section 8. Some may be discriminatory, but other ones are just thinking, hey, well, I know Section 8 already doesn't pay what I want to pay, so I'm cutting all the phone calls out from my Section 8 tenants. So that's what I've been seeing, is they're not reaching market level. Not that they wouldn't rent to them. If they paid market rent, they would certainly rent to them. So that's my 2 cents. I just wanted
and that is accurate, because the voucher only covers up to a certain amount, and if it doesn't come up to market rate and the person, can't make up the difference,
right, they cannot.
Then that's just sort of, that's not a problem that's addressed under the Fair Housing Practices Act. Yeah. No, you are correct.
Hey, thank you. We're gonna have one. Sorry, sure, go ahead.
Yeah, so I did have a follow-up, Lauren. So in a case as straightforward as an advertisement that is explicitly saying no Section 8, can a prospective tenant who sees that, would the guidance be for them in a case to reach out to the Human Rights Commission, again, whether it's a phone call, whether it's walking into the office and having an actual screenshot of this? Because I want to speak about this in very practical terms. They come across an advertisement, whether it's on Zillow, whether it's on Craigslist, Facebook Marketplace, and explicitly says no Section 8 welcomed, or even saying no families or children accepted. They bring that screenshot to the Human Rights Commission. They have the contact information of the respective property owner that is in violation. in that case, is that a situation there where a timeline is a little more expedited because the evidence is already there and the investigators can get started?
The investigators may have to still inquire more about who actually owns the property or something of that nature. But yes, when people bring in, here's the screenshot, then, in some cases we might do some additional testing, like have someone call and verify that that's in fact what the landlord is intending to represent through the advertisement. The other thing is that, a tenant can themselves take that information to the landlord and say, this is a violation of the Fair Housing Practices Act. You can't advertise that you don't accept Section 8. That, puts a lot of burden on the tenant, obviously, or the prospective tenant. But yes, something where it's really clear and someone brings in the evidence, that could potentially speed up the investigation.
And what community outreach efforts are being done so prospective tenants actually know their rights? Because based on what you had shared with us, there were 388 cases that were filed, of which related to source of income discrimination was only 14%. And when you do the math, it basically comes out to less than 60 cases.
It's even less than that. It's 13% of 14% of 383 cases.
So what outreach efforts have been done by the commission to inform people we are the channel and the government entity that you should be reaching out to if you're a victim of source of income discrimination?
So I don't know that we have done any really specific source of income outreach in its own. One of the things that we did in the last year is that we received a grant from HUD to advertise, and we had advertisements that played during the Olympics and a lot of sporting events concerning the commission, fair housing laws, and how to report discrimination. And I think one of the reasons that we have seen such an uptick in cases is because of the advertising. We also do a lot of community outreach at a lot of the big public events, and do trainings on request. But I think that is a genuine concern, is where are the people who need to hear this one thing, and how do we get to them?
Yeah, because I think it'd be helpful if there was even a hotline that people would just tap into. In other words, right, just simply be having access to the phone number of the Human Rights Commission and being able to understand what that process is going to look like. So with that being said, how can the legislature further support the Human Rights Commission so you all have further empowerment to be able to handle investigations in a faster timeline, while at the same time also be able to have the resources to conduct more comprehensive community outreach?
I mean, some of it always comes down to personnel. Like, we could always use another investigator or another support person, or another attorney. And I understand that, money is a little tight and that's not always feasible. But the other thing that's really helpful is, two other things. One is if someone comes to you about this issue, referring them to the Human Rights Commission and saying, the issue you're describing sounds like it's a fair housing issue. This is the number you can call, or here's where you can go. Inviting the Human Rights Commission to come speak to constituents if you are a representative, or you have an interest group that you'd be interested in having us come talk to. We do a lot of public presentations, but I've noticed that we have more invitations for employment than for housing. That would be another one. And, the commission does come up and advocate on behalf of bills that concern our, what's in our anti-discrimination purview. And, having conversations with us when we're up here at the State House is also great. But I would definitely say that if you have a group that you would like us to come speak to, we would love to come and do an outreach for you.
Thank you so much. I'm sorry.
And just my final question, Lauren. What other state agencies, if any, does the Human Rights Commission collaborate or work with?
So the one that we probably work with most often is the Governor's Commission on Disabilities. There's some overlap in our enforcement authority between those two agencies, especially around handicapped access or disability access. We have some co-enforcement authority with the Attorney General's office relating to fair housing cases. I would say that those are the big two.
Thank you, Ms. Hill. We appreciate your presentation. I know that we had a lot of great questions and comments, but I want to be fair to the other panelists that are speaking.